My name is Ellen Joseph. I am the pro bono counsel at Vincent & Elkins. I am thrilled to welcome so many of you here today to learn about defending evictions, how we've been working with Houston Volunteer Lawyers, and how you and your organization can also work with them. We have been doing this work virtually. Our V&E lawyers have, and it's been incredibly rewarding. Our partnership with HVL is, as always, incredible, the guidance and the training that they've provided us. So I'm thrilled to welcome Mary Carmen and Lisa here today to talk to all of you about, Mary Carmen, are you muted? Can someone unmute Mary Carmen? Okay, there you go.
There you go. Thank you. Sorry about that.
We're all still figuring this out 2 years in. This is the story of my life. I am really thrilled to have them here to talk to you guys about how you and your organization can do this work. And so I am going to turn it over to Mary Carmen right away. I'm going to come off video, but the chat will be up. If you guys have questions throughout the program, please use the chat so that we can address those questions as they come. And as always, when this is over, feel free to reach out to me at V&E, and I'm happy to answer any questions your organization might have, or you can always reach out to the folks at HVL. So I'm going to turn it over to HVL, and thank you all for spending your lunchtime with us.
Hi, I'm Mari Carmen Dollar, and this is Lisa Everett, and we both work in the evictions unit at Houston Volunteer Lawyers. Thank you, Ellen, for that introduction and for helping us promote our program. We are at the invitation of the County Courts at Law a year ago, so end of January 2021. We accepted their invitation to come into their courtrooms to provide eviction defense. We created the Eviction Defense Attorney Project, and it started in February of last year. The first 4 months, 3 to 4 months, we were showing up in eviction court by Zoom. And then we changed the program to make it a little bit more efficient for everyone because it was kind of slowing down the courts, and started getting lists of individuals that were unrepresented from the courts. So the courts will send us a list of their dockets the week before. We contact those individuals that are not represented by counsel to see if they are eligible and interested in our services. And then we assign volunteers according to our volunteer pool, which is made up of individual attorneys as well as some law firms that have rotating attorneys. So we are inviting all of y'all to learn about evictions today. By the time that we are done with this presentation, you will be well prepared to represent individuals in county court at law as well as JP court. Our eviction defense attorney project is only in county court at law at this time. It's a little more structured, and it's been very successful. So we're really focusing on that representation. But we invite y'all to listen, learn, ask any questions you have. And at the end, we will let you know how that you can get involved in this program. And so now I'm going to let Lisa take it away with all the substance of defending an eviction in today's world.
Thanks for coming, everyone. We just wanted to start today with a quote from Matthew Desmond, who wrote "Evicted, Poverty and Profit in the American City." It's hard to imagine. It is hard to argue that housing is not a fundamental human need. Decent, affordable housing should be a basic right for everybody in this country. The reason is simple: without stable shelter, everything else falls apart. It's a heavy read in some aspects, but the book reads really quickly. It's super well written, and it's a look at the lives of people living in poverty who are being evicted or at threat of eviction. And I really do recommend it for everyone. But we'll go ahead and start. Today, we've already done introductions. Next, we're going to go over the basics of evictions. We're going to talk about the notice to vacate, the CARES Act, rental assistance, and how rental assistance interacts with the Texas Supreme Court emergency orders, assumed name and franchise tax, and working with pro bono clients. All of this is in anticipation of someone who is wanting to defend someone facing eviction. It is supposed to prepare you so that you are able to defend someone who is facing eviction. So these are some of the abbreviations that you'll see today. I'll say it out loud, but in case you're viewing these slides later on and you're going through it, this is the abbreviation page. The attorneys that work in the eviction unit at HVL right now are myself, Mari Carmen Dollar, and Michelle. Our support staff is Max and Natalia. And so if y'all have questions, like substantive questions, reach out to myself, Mari Carmen, or Michelle. Michelle is also observing, and she can, if y'all have questions, by the way, put them in the chat. Mari Carmen will be monitoring it, and she can either answer in the chat or she can interrupt me so I can answer your questions. And if you have questions about signing up or getting on the volunteer portal or becoming more involved, reach out to Max or Natalia and or Mari Carmen.
And we're going to provide that information at the end.
Yes. So first, whenever you're looking at eviction, you need to know what the rules are that govern eviction. One of the places we always want to see is the lease agreement. I have a link to a sample Texas Apartment Association lease agreement. It's pretty standard. It does change every couple of years, you know, with the legislative sessions, but it's pretty consistent over time. This is a sample 2019 lease. There's also, and that's for multi-family unit apartment complexes. There's also the Texas Association of Realtors or Texas Real Estate Commission sample lease, and that's normally for the individual dwellings, a single family home. And even though I sometimes hear people say, I don't have a lease because it was oral leases are valid in Texas. The Texas Rules of Civil Procedure 500 through 510 deal exclusively with cases in JP court. And 510, Rule 510 explicitly deals with evictions. Every residential eviction is required to start in JP court. They have original jurisdiction. And so when you're looking at JP court or evictions, it's good to know where it starts. Our program is centered on representing people in county court at law. So it means that they have lost at JP court and they have appealed the case to county court at law, where it's a trial de novo. But still, some of the rules derive from the 500s and 510. Texas Property Code Chapter 24 is the forcible detainer chapter, which is a fancy word for eviction. Other property code chapters that deal with evictions are 91, which is super short. 92 deals with residential tenancies, and 94 deals with manufactured home tenancies. You only need to look at that for the manufactured home. That's very limited. The assumed name and franchise tax statutes that we're going to be looking at the end come from Texas Business and Commerce Code, Chapter 71 and 171. And we're also going to be looking at the CARES Act. So in an eviction, the fundamental question is who has the superior right of possession? An eviction is the right to possess the property. When a landlord sues for eviction, in addition to requesting possession, they are allowed to request unpaid rent, the cost of court, and attorney's fees. They are not allowed to request utilities, late fees, or other charges. There are no counterclaims in evictions. That comes from Rule 510. Sorry, I'm not sure. I don't have all the 510s memorized, but it's in Rule 510 that there are no counterclaims. That really surprises and upsets some of the tenants who are upset at, lack of repairs and other conditions, but there are none. However, it does not preclude bringing an affirmative case in another court. Also, the jurisdiction at county court at law is limited to the jurisdiction that the JP court had. I apologize for the small print in this, but the basic steps for an eviction is that there's a breach of the lease or a default, a breach, or a holdover after the lease has been terminated. The most common default or breach is non-payment of rent. I don't actually have statistics, but I would be willing to bet money that is over 90% of the evictions. When there has been that breach, default, or holdover, the landlord is required to give a notice to vacate, and that's Chapter 24005 of the Texas Property Code. I see that Mark's asked if the landlord can seek damage to the property. They cannot seek it in the eviction action. They can sue the landlord. The landlord can sue the tenant separately, or if there's damage after the tenant's moved out and an itemized deduction has been sent regarding the security deposit to the tenant. If there's additional damages, they can also report them to the credit bureaus, or they can sue the tenant separately. So they have to give a notice to vacate. The notice to vacate is a central component of the eviction suit. After the notice to vacate expires, if the tenant is still in possession, because the vacate says you have to vacate, if they don't vacate, then the eviction is filed in JP court. The tenant is served by the constable. The constable is the only person who can do service in JP cases. And then there is a trial. If the tenant loses, they can appeal. The tenant has 5 days to appeal. It is super short. It is not the 30 days allowed in most other cases. If it's appealed, there's a trial de novo at county court at law. JP courts are not courts of record. There is no record. They send up a transcript, but the transcript is a list of fees and cost in the court. Most of our clients qualify for a statement of inability to afford payment of court costs or an appeal bond, which waives the payment of an appeal bond and waives the filing fee for county court at law. If there is no appeal, after the 5 days to appeal has expired, the day after, the landlord is allowed to request a writ of possession. We are going to go in detail through Texas Property Code 24005 because that is a great source of defenses for us in a eviction. So if the lease agreement, I'm going to summarize these for the most part because there's a lot of text coming up. If you're ever taking an eviction, I strongly urge you to actually read the entire text of 24005 of the Texas Property Code. In general, if a person is under a lease, the landlord has to give a 3-day notice to vacate unless the lease specifies another time. The standard TA lease and the standard TAR lease have a 1-day or 24-hour notice to vacate. And that is the shortest we see. It's very, very common. I don't understand how anyone is supposed to be able to move with 1 day's notice. I have resources and I couldn't move in a day. So I don't understand how that's possible, but it is what it is. It also says that at the end of this chapter, can y'all see my mouse when I'm moving it along? Right, Carmen, can you see it?
Yes.
Okay, so a landlord who files a forcible detainer suit on the grounds that the tenant is holding over beyond the end of the rental term or renewal period must also comply with the tenancy termination requirements of section 91.001. That basically says if a person is on a month-to-month lease, they have to be given 30 days notice or to the end of the month, whichever is later, notice of termination. And then if the tenant stays past the termination date they have held over, they're required to be given a notice to vacate. The Texas Property Code 005 says that if they're not there under a lease, then they still have to get 3 days notice. There are special rules for people who are staying after a foreclosure. If a person is a tenant of a home that's been foreclosed on, there are special federal protections, and that's the Protecting Tenants at Foreclosure Act. I have a link to that down here. That is only available to tenants in homes that have been foreclosed on. It's not available to people who were the homeowners who have been foreclosed upon. And if someone is foreclosed upon and they're still in the home, a new owner is allowed to evict the former owner. Tenants who had a valid lease are actually allowed to stay longer under the Protecting Tenants of Foreclosure Act. And that's you have to look at the facts and specificities to see if that applies or not. Most of our clients are regular tenants in apartment complexes. This just says notice to vacate has to be given. There is this one section right here, 24005E, that says if the lease or applicable law requires the landlords to give a tenant an opportunity to respond to a notice of proposed eviction, a notice to vacate may not be given until the period provided for the tenant to respond to the eviction notice has expired. That's talking about certain HUD housing or Section 810. It especially applies to if someone is in public housing and some other HUD federally funded programs. If we think that someone is in a situation like that, we'll often raise it, and sometimes it is a defense as well. Section 24005 has become, 005F has become a common defense that we've been using since the pandemic began. The notice to vacate is required to be given to an individual who's 16 or older at the premises, posted on the inside of the door, meaning you have to unlock the door, open it up, and tape it to the inside, or it can be mailed via regular mail or tracking mail. The only circumstance under which the notice to vacate may be given on the outside of the door, which we're going to get to in the next slide, requires also for it to be mailed. It has a lot of other requirements. I just want to point out that a lot of our clients also tell us that they're sometimes getting notices to vacate via email and text messages. Those are not valid ways to give a notice to vacate in Texas. The tenant can say, yes, I got it, but it doesn't matter that they got it. It has to comply with the law. Oh, hold on just a second. Okay, so Property Code 24005 F1 says that if a landlord is not able to access the inside of the door to post that notice to vacate on the inside of the door, they are allowed to leave the notice to vacate on the outside of the door as long as all of the following requirements are met. And that's that it has to be in an envelope that has important document or something substantially similar. It has to have the tenant's name and address on that envelope as well. And on the same day, they also have to mail it before 5 p.m. If they're just mailing it regularly, like and not posting on the outside of the door, they don't have to prove it was done before 5 p.m. But if you're leaving on the outside of the door, you also have to mail it before 5 p.m. And you're only allowed to do this if the premise has no mailbox and a keyless bolting device, our alarm system or dangerous animal, or some other reason that prevents the landlord from entering the premises, or that the landlord reasonably believes that there would be harm to someone if they were to open the door and post it on the inside of the door. Prior to the pandemic, whenever we asked people where the notice to vacate was, I almost always heard it was on the inside of the door. Since the pandemic began, landlords have been leaving it on the outside of the door with greater and greater frequency. But they're putting on their petitions that they're putting on the inside of the door. And I think it's because of the pandemic. It is not an excuse under here. There's no pandemic reason. And that hasn't been raised as a defense to like, they believe there was harm. And even if they did, they're still not mailing it the same day. And they're just either folding it up and taping on the outside, they're rolling it up and sticking it in the nail knocker, or they're folding it in half and slipping it in between the door frame and the door. And so that's actually not compliant. It's missing an element of the case, and there's case law where decisions have been overturned because even though they've proven they did the part with the envelope, they didn't prove they mailed it before 5 p.m. So it's important to ask those questions. We're going to skip all of this because you can read it later. But the big summary about 24005 is that 3 days notice is required unless the parties contract for a shorter or longer period, or unless there's a law, ordinance, or emergency order. The standard home and apartment leases have a 24-hour or one-day notice to vacate, and the notices to vacate must be placed on the inside of the door, mailed, or hand-delivered. So in Texas, evictions are a statutory remedy, and they require strict compliance with the statute, which is why we spend so much time talking about 24005. Historically, it's always been one of our bigger defense mechanisms, even before the pandemic. Were mistakes with that one way or another. So the other thing that we use with notices to vacate is when it's been mailed. Sometimes landlords will mail it on, February 1st. The postmark date might not be till a couple days later. We always ask clients if they receive the notice to vacate via mail, if they still have the envelope, because sometimes it is not postmarked the day that it's printed on the inside. But there are also rules about adding 3 days for mail, with the exception of 24005 F1 that says if you put it on the outside of the door and mail it, it's counted delivered the day it's posted on the door. Any other time it's mailed, you have to add 3 days for delivery and then time to that for them to vacate, depending on how long the notice to vacate said that they had. Even though the standard lease agreement says 1 day, 24 hours, we find that most landlords are giving 3 days notice anyways. So just be aware that, because we do count, whenever it's sent via mail, we count, and sometimes we find that the landlord has filed the eviction prior to the notice to vacate expiring due to an addition of like adding 3 days for the time to respond. And so sometimes we're getting cases dismissed for failure to give a proper notice to vacate or filing the eviction too soon. Another defense is that they're leaving on the outside of the door without following all the proper procedures. that will also result in a dismissal if you're able to prove it. And like I said, that's been happening more and more since the pandemic began. Another thing is that the notice to vacate is required to be given to all the tenants under the lease. Most landlords follow this. It was a change in the law. So if Jane Doe and John Doe are on a lease and they have their kids, Innie, Minnie, and Miney, Jane and John Doe have to be named in the notice to vacate. They have to be told to vacate. The occupants, or which are normally the minor children, should not and do not need to be named in the notice to vacate. When they are sued, each occupant obligated is also supposed to be sued. If you just do and all occupants for the notice to vacate, that's insufficient. The other defense that we use somewhat frequently is that landlords will give a notice of termination, that they're going to terminate a lease, and they combine that with a notice to vacate. When they do that, they have not given a notice to vacate. When you are terminating a lease, there is no breach and there is no holdover. When you're giving a notice to vacate, it's because something bad or wrong has allegedly happened. When you are terminating a lease, there is no grounds for giving a notice to vacate. And if you give it together, it's premature and there's no notice. And if there's no subsequent notice to vacate, then that's another grounds for dismissal or a take nothing judgment.
And additionally, we find they gave one or the other, but not both in the order they were supposed to give them. They will have given the termination and think it's a notice to vacate, or given the notice to vacate without giving the termination.
And one time I even saw a notice to vacate, then a notice of termination. And so that one was an easy one for the judge. Okay, we're going to discuss the CARES Act very briefly. This was passed March 27th, 2020. I should probably add a year on here now because it's been going on for a while. There is section 4024, which is pages 212 through 14 in the link that I provided. The title of that section is the temporary moratorium on evictions. I don't know if y'all remember back to 2020, but there was a temporary moratorium on evictions for a little while for covered properties. The moratorium has expired. However, section C of the CARES of 4024, the CARES Act, states that tenants living in covered dwellings or covered properties are required to receive a 30-day notice to vacate before the eviction can be filed. And there is no expiration of that. It's pretty, although there's some disagreement among landlord attorneys, it is pretty well established that everyone believes that this is a permanent law, that tenants of covered dwellings are required to receive 30-day notices to vacate. And most landlords who are landlords of CARES Act properties are giving 30-day notices, but we are always still checking. Covered properties are basically any housing program covered by VAWA. I have a list of what that includes. I'm not going to read them all, but I am going to let you know that what we see most common in Houston is the housing choice voucher, where the housing authority subsidizes rent to a private landlord, housing for the elderly, housing for people with disabilities, and the low income housing tax credit units. That's actually not a HUD program. That's an IRS program that offers below market rates. If you want to see the sites for any of these, the National Housing Law Project has sites to why all these are covered. Also covered properties are any property with a federally backed mortgage loan. Everyone likes to say Fannie Mae and Freddie Mac, but it is every federally backed mortgage loan. So that includes HUD, USDA, FHA, VA, Fannie Mae, Freddie Mac, and Ginnie Mae. What else is a covered property? It's any loan made in whole or part or insured, guaranteed, supplemented, or assisted in any way by any officer or agency of the federal government or under in connection with a housing or urban development program administered by HUD or a housing or related program administered by any other such office or agency, or is purchased or securitized by the Federal Home Loan Mortgage Corporation or the Federal National Mortgage Association. That means pretty much that if the loan is serviced by or owned by a federally backed entity, it is a covered property. Right when the CARES Act was passed, the Congressional Research Service issued a paper that said that approximately 28% of renters have federally backed live-in rental units that are have federally backed financing. And then other data shows that there's more than 2 million housing vouchers, along with approximately 5 million federally assisted rental units. There is some overlap between these numbers, but that means there's more than 28% of renters that are covered by the CARES Act. Unfortunately, we don't always know if a rental unit is covered. Only an owner has access to know who their loan holder is or their loan servicer. If any of y'all are homeowners, you can go to the MERS website, type in your address, your social security number, click that you are the homeowner, and you can find out who owns your loan. It's probably not the person you took the loan out with whenever you made your home loan. I have checked. I checked at the beginning of the pandemic, and it was different for me, and we've since refinanced, and it has changed hands again. So I'm just letting you know it changes. People don't know who holds it. They may know who services it, but they don't know who actually holds it, and only the owner is allowed to access that information. There are some search features, though, for properties that are known to be a covered property or suspected, I should say suspected to be a covered property. The one that I like to use a lot is from TRALA, which is Texas Rio Grande Legal Aid. A legal aid, they cover a third of the state with legal aid, but their map covers the entire state. That'll search the LIHTC properties, the low income housing tax credit properties, obviously public housing, the housing for the elderly, the housing for the disabled, and a few others. It doesn't find every single thing, and occasionally it will have properties on it that might have had a Fannie Mae mortgage, but maybe it's been sold since the map data was uploaded. So it's not conclusive. So it's not conclusive in that it does not include every property, and it's also not conclusive in that some properties that might show up might not be a covered property any longer. So just be aware of that. Every now and then, we will actually find that someone has a federally backed mortgage by looking up the real property records here in Harris County. You'll see that it's guaranteed by the VA or some other organization, so that can be helpful as well. Freddie Mac and Fannie Mae, a few months into the pandemic, maybe 6 months in, made a renter lookup tool so that you can check for those. There isn't a tool for the other programs I listed, though. The Ginnie Mae, the FHA, no, there is one for FHA, I'm sorry. I'm going to update that before I send it out. There's a few more federal lookup tools that we can do on here. Most of them will be caught in this Texas map, though. There's rental. I don't know if y'all have heard about all the rental assistance available to renters. It's funded by the Treasury and funded by one of Biden's. I don't remember what they're called. I'm not going to pretend I know what they're called right now. But the two main programs that have been assisting renters in our area are the Houston Harris County Rental Assistance Program and Texas Rent Relief. This is the website if you want to go look at it. Right now, they've run out of, they have expended almost all of their funds. Basically funds went out across the nation at the beginning of when these bills were passed to fund rental assistance for renters. That goes mostly directly to landlords. Just so it's a program where landlords are encouraged to apply and the tenant is encouraged to apply. When a tenant applies, they're actually supposed to search by the address to see if their landlord has already applied. If a landlord has applied to receive the rental assistance, if their tenant is approved, the money goes straight to them via direct deposit to the bank or via check. And when they sign up for that, they agree to certain rules and conditions. At some point, some jurisdictions were not distributing money in a good manner. And so some of the money was returned to the federal government and they've redistributed some of it. Within Texas, 2 jurisdictions got more money, and that was Houston, Harris County, and San Antonio. But right now, the portal to apply for rental assistance for Houston, Harris County is only open to people with pending evictions. If you want to read the landlord terms and conditions, those are here. It has things like if there's a pending application or an application has been submitted and they're participating to receive the funds directly, they're not supposed to file an eviction. They're not supposed to prosecute an eviction or get a writ of possession. I can tell you that a lot of landlords violate those rules right and left, and you can look up who all is participating in the landlord directory here. The Texas Rent Relief Program website is available at texasrentrelief.com. their portal is completely closed. They still are working out a few they still have pending applications from the time that before they closed the portal, which was early to mid-December? It was in December.
November.
Okay, excuse me.
December.
Okay. It was closed last year, but they are still processing applications that had already been submitted prior to the portal closing. So we're still looking at that and asking if people have the pending applications. Also, under both of these programs, a person, when they're applying for rent assistance, so like, let's say they submitted an application in November, they were allowed to apply for up to 3 months of future rent. So they were allowed to apply for December, January, and February rent, in addition to November and past due rent. And so some of these programs, people are getting money and it's covering rent that's currently becoming due. And so we're always checking that. The Texas Rent Relief Program does not have a publicly searchable database. You can only find out if the landlord is participating by logging into the tenant portal and seeing if they have a verified landlord. If you want to see what the guidelines are regarding the use of these funds, Treasury guidance is available at this link. The Texas Supreme Court has been issuing emergency orders pretty much from the get-go of the pandemic. The most recent ones that concern evictions, or the most recent one, or the one that's in effect right now, is Emergency Order 46. And Emergency Order 46 says that if a landlord has provided information for the purposes of receiving rental assistance and the tenant has a pending application, then if there is a pending eviction at JP Court and County Court at Law, it says that the case must be abated for 60 days. The court records must be made confidential immediately at the County Court at Law level and JP Court level. And if you have a case at County Court at Law, they're supposed to instruct the JP Court to make the underlying records confidential as well. And the case is supposed to be dismissed with prejudice. There is a mechanism for the landlord to reinstate the case if during the 60-day abatement period, the case is denied, the application is denied, canceled, or withdrawn, then the case may be reinstated. The abatement period can also be continued another 60 days if an application is still pending at the end of 60 days and the landlord requests an extension of the abatement. Otherwise, at the end of the 60-day abatement period, the case is dismissed with prejudice. I have a link to this link to the emergency orders only has the most recent one. If you poke around on the texascourts.gov website, you can find other emergency orders that have since expired. The emergency order 46, which is the link here, expires March 1. There's a couple reasons why we like the emergency orders and the rental assistance. One is the making the records confidential and dismissing the case with prejudice. And another reason is if a landlord won't participate in the programs, we are seeing judges refuse to grant past due rent in a judgment, along with the judgment for possession due to the landlord's failure to mitigate. So while it may not save a tenant from eviction, it can sometimes save them from a judgment that might have otherwise been substantial if a landlord's refusing to participate in the rental assistance programs. So we're always asking the tenants, they're allowed to apply even if the landlord has not. And if the landlord said, I'm not signing up, some of the judges don't have a lot of patience for that. A lot of money went out. And for landlords who just didn't want it, the judges don't always have a lot of sympathy for. And I mean, quite frankly,
and again, the opposite happens too.
But quite frankly, failure to mitigate is a defense to a contractual breach in Texas. Another place where we see, I don't know, it's a defense, it's a delay more than a defense, although it can be a defense, is checking to see whether or not someone has an assumed name certificate on file where it's supposed to be. We most commonly see it for our incorporated businesses, and that includes corporations, LLCs, partnerships, limited partnerships. I'm not going to list the whole thing. They are listed in Chapter 71 of the Texas and Business Commerce Code. For people, i.e., unincorporated business, if I'm Lisa Everett doing business as Eviction Defense galore, then I have to have a assumed name certificate on file with the county because I'm a person. If I am doing business as Eviction Defense LLC, then I have to have my assumed, and I'm operating under assumed name of just Lisa Everett Galore, then I have to have my assumed name certificate on file with the Texas Secretary of State in Austin. And we find a lot of people don't have assumed names. If someone does not have an assumed name on file with the Secretary of State, then they are not allowed to maintain an action or proceeding in this state. They are allowed to defend, but they are not allowed to maintain. So we have a sample motion to abate. It has to be verified to abate the case. And if they don't correct the deficiency, then we ask for the case to be dismissed. The franchise tax, every incorporated business has to, or I shouldn't say every, it's defined what type of businesses have to pay franchise taxes in Texas Business and Commerce Code 171. The failure of an entity to pay those taxes can lead to the forfeiture of the corporate privileges. And if the corporate privileges are forfeited, then they may not sue or defend. So you can sue them and they don't have the right to defend in a court of the state. Again, we file a motion to abate. They have a chance to correct the deficiency. And if they don't, then we ask for the case to be dismissed.
And it's not unusual to see this. We've got several cases where we've managed to get additional time based on franchise tax issues or assumed name.
Right, Carmen's right. Also, and the way we check it first is whenever we have a case, we go straight to HCAD. Our cases are all in Harris County, and we see who the presumptive owner is. HCAD is not definitive, but it's right 99% of the time. Or sorry, I keep calling out quotes. It's often correct as to like who the owner is. And so like we might see someone being sued as, you know, they've been sued by ABC Apartments, but the owner according to HCAD is XYZ Apartments LLC. And so that's their assumed name. I might check the real property records to confirm it's correct as well. And then I go to the Secretary of State website to look to see if they have an assumed name file on file. And I print those and I submit them as my evidence in court. It's a business, it's a record that's published and maintained by the government. So it's a hearsay exception, excuse me. Yeah, yes, excuse me, it's an exception. For the franchise tax, you can do a free search at this link, but it's not the one that I actually submit when I'm, if I'm trying to prove that someone's tax status has been forfeited. If I've confirmed it at the free site, then I go to the Secretary of State and do my $1 search. It's very, very affordable. HVL does these for our cases before we hand them over to you. In almost every case, every now and then, if there's some other very, very clear defense, we might not do it because it doesn't get that far and we don't need to. So we'd like to talk about why tenants need your help. I know that we started this conversation with a quote from Matthew Desmond about how we believe that housing is a right. When tenants have to find new housing, it's more difficult and more expensive following an eviction. Once an eviction is on their file, they normally have to, a lot of tenants don't realize that many apartment complexes will not rent to someone who has had an eviction filed against them, even if they prevail. And Mark is right. If the charter has been forfeited, the directors can be personally liable for the liability of the corporation. He is absolutely correct. Because there's no counterclaims in the evictions, though, there's not really much liability per se in the eviction defense, but Mark is correct. So when the eviction's been filed, it can be more difficult for them to find housing. One, they'll put in applications at places that won't rent to people who have had an eviction filed against them, or won't rent to people who have had evictions granted against them, or they have to pay higher security deposits. The children, when people are forced to move, children have to change schools.
Lisa, can I interrupt you real quick?
Yes.
One thing that I really wasn't cognizant of until recently, and I was reading about evictions, is it costs money every time they fill out an application for a new unit. And so if they're being turned down, they're spending hundreds of dollars that they don't have, or they don't have it, so they can't spend it to try and find a new place. And so it's really significant when you can't get housing because you have an eviction on your record. And that's why Emergency Order 46 that makes records confidential is so important.
My comments are exactly right. And just so you know, there's a lot of landlords who are accepting the rental assistance money, but aren't having the cases dismissed. They're non-suiting cases. And when the case is non-suited, that eviction record is still out there. There may not be the, it might be the equivalent of a dismissal, but that eviction record's still out there and it's still harming the tenant. And it's not supposed to, like when they sign those agreements with Texas Rent Relief explicitly states that they're supposed to participate in the programs to have the records made confidential, and not doing so is a violation of the program. I can't tell you that like no landlord that I've ever seen has actually brought up, we got it, so we want it, we want the procedures followed. At JP Court, surprisingly, JP Court tends to be very tenant unfriendly, but the JP judges have really embraced this idea of like making if they say rent assistance and landlords say rent assistance, then they'll make the records confidential in some of the courts and follow the rules that they're supposed to follow. The county court at law judges are subject to these same rules, but if the landlord doesn't request it or the tenant doesn't request it, they just allow the non-suit to go through, or they hear that there's rental assistance, but they're not making the records confidential. They're just non-suiting. And so it's disappointing to see that it requires such affirmative action by the tenant to get the relief that they're supposed to be entitled to, and that all these courts are subject to pursuant to the emergency orders, but they're just not. So when families are moving unexpectedly, they're losing their belongings. Sometimes they can't take it all with them. If they are moving, if you take a day off from work, you can lose your job. There are mental health consequences of evictions. There's higher rates of depression. And while I think most people would think that poverty leads to eviction, to some degree, eviction also leads to poverty. And that's because you're moving unexpectedly, you don't have the funds to move, you may not know anyone with a truck, you may not be able to rent a truck, and so you've left your bedroom set behind. When you start over somewhere else, and you're already paycheck to paycheck, you don't have a bedroom set anymore, and it's losing all your belongings that is problematic. When you are taking a case through Houston Volunteer Lawyers, you're working with a different client base than most of you would work with in your regular practice. An eviction may not be the only issue in our clients' lives. There might be other conflict or trauma. Sometimes it's combined with the job loss, which is a whole, that can also lead to depression and other issues, and just general poverty, like wondering how the car has also been repossessed. They're applying for food stamps for the first time in their life because they can't put food on the table anymore. It's a whole host of problems often. So we want to be cognizant of that, and we want to approach our clients with empathy and without judgment. So instead of, why did you decide to do this instead of this? It's getting the facts so that we can defend them and not judge them. Most of your corporate clients are probably definitely more sophisticated than most of our clients. Some of them have lower levels of education, not all of them. Just because someone is poor doesn't mean they're uneducated, but we do find a number of unsophisticated parties. And so sometimes we will ask them to repeat or summarize what we've said because we want them to understand what's going on also. And we also want to set realistic expectations. We're not going to win every case we get in the way that we think of winning other cases, and they need to be prepared. And when we do our initial intake interview, and we're interviewing them to see if we're going to represent them, we do try to manage their expectations. So for example, maybe we see that someone has a bad notice to vacate, and we might say, we anticipate being able to get a take nothing judgment because this element that the landlord is required as an essential element of the case isn't there. But that means that they are probably going to give you a new notice to vacate the day of, after court or later that week, and the eviction process is going to start over. Or, luckily in some of these cases for the past however many months, we've been able to get them dismissed because of the rental assistance, and they're good to go. But those cases are becoming fewer and fewer. And so we're not always able to, like, a win just might mean that there's about to be another eviction. Oftentimes people need more time, and so that's a win for them. We also encourage our volunteers to try to work out agreements with the landlord if it's in the benefit, for the benefit of the client. Some people are going to, even maybe there's a good defense, maybe there's a good notice to vacate defense, or there's every now and then, people sue in the complete wrong entity name. There's a jurisdictional issue. But if the client says, I can be out in 2 weeks because I knew this was coming, but they need a little more time, they'll agree to dismiss the case if they'll move out. And so we just always want to evaluate what's best for the client. And we do try to tell them what can and can't be done. And then of course we always, even if we think there's a good case, if any of y'all have ever been to court, you know that you can never guarantee what's going to happen in court. We believe that representation is important and it matters. In Texas, the landlord-tenant law is definitely slanted towards the landlords. We're going through like these narrow defenses, and we're saying like this is how you can win a case, knowing that there might be another eviction right around the corner. However, the tenant doesn't get that time often if they don't have an attorney representing them. I know that I've watched trials online with pro se tenants, and when you don't have someone objecting to the landlord's hearsay or other things like that, then the judges are letting it go forward because there was no objection made. And so we can do things for the tenant that the tenant may not be able to do on their own. Also, we can help negotiate move out agreements or settlements with the landlord, and it's not going to be as lopsided. There's a couple of major landlord firms in town, and their template, their boilerplate settlement agreements, surprisingly shocking, only favor the tenant, only favor the landlord, and are so one-sided as to honestly to be a little unconscionable, in my opinion. They're already at a disadvantage because the law favors landlords. But I've had people tell me, like even when we've lost a case, that I listened to them, and that was important to them because they felt that no one else listened to them, and someone was actually standing up for them. And we might have like flat out lost, but I've still been told thank you for advocating when they felt no one else would do that. And another reason is that sometimes the tenants misunderstood the law. Aside from an inability to pay rent, which is pretty common nowadays, the biggest reason why rent isn't paid is because the tenant has withheld it because repairs weren't made. In Texas, if you don't pay rent, the landlord doesn't have an obligation to make repairs, and they're allowed to file an eviction. And we hope that maybe if they've made that horrible, horrible mistake, and maybe it was legal if they live somewhere else. I think in DC, you're allowed to withhold for like, when repairs aren't made. But here in Texas, that's like a one-way ticket to an eviction. And so we hope that next time around, they won't make the same mistake. These are some helpful links. The first one is where you can watch trials. It's for county court at law, JP court, and the criminal county courts. The JP homepage has, if you're trying to look up certain records, sometimes it can be helpful to go to the JP site. Sorry, I'm going to skip all the JP ones. The Harris County Court at Law and Real Property Records. This is if you want to look up the court records for a case at county court at law, or if you want to look up real property records in Harris County. And also the Texas Justice Court Training Center has a lot of useful information, including their publication called the Evictions Desk Book. I call it Evictions for Dummies, and they publish it for all the JPs across the state. I am not calling our JPs dummies, but I am saying it's written that way. It's written to, for a basic understanding. You don't have to be a lawyer to be a JP court judge. You don't have to have a college education. And I've even read a statistic, there's a couple of JPs in Texas that don't have a high school education. And I think a lot are not college educated either. It's an elected position with like virtually no requirement. In Harris County, we're lucky in that out of our 16 judges, I think 14 of them are attorneys. So we have a higher qualified JP bar in Harris County, but it's a really, really great resource if you're just trying to get basics on evictions. Sorry, I'm about to mute myself. I'm going to let Mari Carmen take over on the questions. We have 8 minutes left. If you're attending today, this is your CLE information, our phone numbers and our email addresses. And I'm going to mute myself because I can hear the dog.
Thanks, Lisa. So I want to pick up where I left off in talking about our eviction defense attorney program. And we want to invite all of you and your firms to think about volunteering for our program. So far, since February of 2021, we have placed 134 cases with volunteers. I know V&E is, they helped us get started. And I'm going to say right now that we've got a superstar over there. His name is Josh Windsor, who's taken he's not on the program right now, but in the beginning, he took, I think the count is like 18 cases overall in his tenure. So anyway, we've got right now Baker and Botts is also helping out a lot, Hunt and Andrews Kurth. And I know there are several other firms that are also offering their assistance. But what we're looking for is to continue building our volunteer pool so that we have the capacity to take as many cases as we get calls for. So the way the process works is the court sends us the week before trial, the court sends us the eviction dockets. We make the phone calls to all the unrepresented individuals, and we go ahead and figure out by the middle of the week how many we have. At that same time, Max is reaching out to our law firms and our individual attorney volunteers, asking who's available on these dates for next week. And then we put our list together with those that have called us, together with the volunteers, and try to get everyone assigned. Every once in a while, we do have a need to reach out individually to volunteers just so that we can try and get everything covered. And then, of course, we do take some staff cases, but since that is not our main mission at HVL, we try not to take them too often because sometimes they do require a lot of work, and it is, we'd rather be mentoring and helping and reviewing the cases. When we provide these cases to you, they're going to come with a referral summary, and it's going to have a list of the facts, a list of the suggested trial strategies, and templates. Lisa has been instrumental in making, we have templates for almost everything. And so as a staff attorney, when we're reviewing a case and putting together a referral summary, we're also attaching the templates that we think you're going to need. We will put the information on rental assistance that you need if that's relevant. We'll try to put case law if that's required, or a link to the statute, the Texas Property Code. So we try to give you everything, and that's because these are quick cases. We're getting them the week before. We place them on Thursday and Friday, the following week for Monday, Tuesday, and Wednesday trials. So there's real quick turnaround. So we're trying to do as much work as possible. A lot of times we're going to do, I think Lisa mentioned this, is we're going to do what's most obvious and what we feel are the best defenses. But a lot of times, especially with repeat volunteers, they're starting to find their own things. And they call us and say, hey, can I raise this? Can I raise that? And we're like, of course, this case becomes your case. And if you've done this enough, you start recognizing everything. I'm answering a question here. Somebody's asking about the slides. We're going to send out an email this afternoon asking for those who are interested in participating in our volunteer pool. I'm going to attach the slides to that request. And then if you are interested in signing up for our volunteer pool, we're going to attach a volunteer guide and a cheat sheet that we have for you as well. So I just want to finish off by stating that 3 reasons for you to get involved in our program. And the first obviously would be to give representation to the tenant for all the reasons that Lisa mentioned. The second would be to assist the courts in continuing to run an efficient docket and make sure that justice is served for the tenants. And then the third reason would be overall experience. We have been told by various volunteers that this has given them a great opportunity to work on their negotiating skills, to with opposing counsel, to present their cases in court, to talk to judges, and to work on trial skills and evidence and procedure issues. So there are a lot of reasons to get involved in this program. It's the Eviction Defense Attorney Program. We're really hoping that you will consider it, and I want to thank you for attending today, and thank Ellen for hosting this.
Also, I'm just gonna plug volunteering. If you do any litigation, it is a great chance to be in front of a judge. We know that most cases settle and not everything goes to trial. These are trial settings the following week. Occasionally, you get put into a breakout room before your trial and you can work something out before trial, but it's a great chance to be in court. If you are a transactional attorney or not a litigator, the county court at law judges tend to be friendly and nice to everyone. I mean, to most people in their courtroom, quite frankly, and give a little bit of leeway, and they will prompt you along. I can say that I was objecting last week to someone who hadn't asked to have her exhibits admitted, and the judge was like, "Are you asking to admit your exhibits?" And she was like, "Yes," and they will do the same for you too. So you shouldn't be intimidated if you're not a regular litigator, and we can give you some tips for going to court if you need that. I would also like to let y'all know that we are finding some landlords who have accepted the rental assistance money aren't applying it correctly. Like, so for example, let's say someone fell behind for 6 months and they got 6 months worth of rental assistance. For the period that was covered, they're supposed to come out of that rental assistance with a $0 balance. And we're finding landlords who are not waiving fees that they are supposed to waive pursuant to the agreements they made with the rental assistance through Houston Harris Health or Texas Rent Relief. And they might say, "Oh, you got this 6 months, but now you still owe us $2,000. And we're not going to accept your rent next month if you don't pay rent plus the $2,000 you owe." We are suing some of the landlords who are unwilling to fix the ledgers after a polite request. And so if anyone is interested in a bigger case, we have those too. We have several cases pending from volunteers right now. And so we have sample petitions for those as well to help get you started.
All right. Thank you so much. We appreciate it.
Thank you.